Potentially great news out of the state of New Jersey in support of our Second Amendment right to keep and bear arms in particular. An issue associated with New Jersey's attempt to ban concealed carry statewide. Stay tuned. We'll talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. And we're working really hard to try to get to 100,000 subscribers because we think it's going to make a big difference for the social media algorithms going forward. All right, folks, this is geeky. Big news, I think very good news for those gun owners in the state of New Jersey, although it's not going to be apparent on its face. Here's what just happened literally 2 hours ago. Federal District Court judge, that's a trial judge, Judge Renee Bum, a George W. Bush appointee to the federal bench, just entered an order to show cause. Specifically, she has set an extremely fast briefing schedule on a lawsuit that was literally just commenced before Christmas by the Second Amendment Foundation and by the Firearms Policy Coalition, FPC. And this lawsuit challenged the new law that essentially converted New Jersey from allowing you to carry guns wherever under the new Bruin standard to not being allowed to carry guns basically anywhere, including in your car. Now, much of this law is likely unconstitutional for reasons we've talked about before. But of course, none of that matters what I think. It's what the courts think at the end of the day. And the good news here is, here we are on a federal holiday. Today is a federal holiday. Federal courts are closed today. And yet Judge Renee Bum, a federal judge in New Jersey, has just entered an order requiring expedited briefing and setting up a preliminary injunction hearing on January 5th. Her briefing schedule actually requires the state of New Jersey to file their opposition papers to the motion for a preliminary injunction, striking down all these so-called sensitive places laws. Not all of them, because they only challenge some of them. We'll talk about that in a second. But basically, the defendant, the state of New Jersey, and all the prosecutors that would otherwise be required to enforce these gun control laws have until December 30th, that's Friday, I believe, before New Year's Day, to file their opposition papers. And then the plaintiffs, as Second Amendment Foundation, Firearms Policy Coalition, Coalition of New Jersey Firearms Owners, and the New Jersey Second Amendment Society, all have to submit their reply papers in support of their motion to strike down these sensitive places laws by January 3rd, and a Zoom hearing has been scheduled for January 5th. This is extremely fast for a federal court to be acting. Now, while this does not tell us exactly what Judge Bum's going to do here, it certainly does suggest that she has taken this very seriously and has concerns and wants to hear from the state of New Jersey about how they think they can get away with what appears to be a blatant violation of the Second Amendment based upon the interpretation of the Second Amendment of the right to carry, which is the right to bear means the right to carry, in light of Nysurpa versus Bruin. So this federal judge acting so quickly is a very good sign to New Jersey gun owners as I see it. And just as a reminder, the lawsuit here by the Firearms Policy Coalition, the Second Amendment Foundation, seeks to basically enjoin four key parts of the sensitive places law, the new one from New Jersey. Specifically, it goes after the fact that you're not allowed to carry guns in your car. How the heck is a car a sensitive place? It's it makes no sense. Especially if you're by yourself, it makes no sense. And there's no history for that because, as I've written about before and talked about before, there's specific examples where Thomas Jefferson would travel with his firearms and Andrew Jackson would travel with his firearms during the founding era. So obviously there was no restrictions on the ability to carry guns when you traveled. If anything, that was the best time to carry guns when you traveled from place to place to deal with potential robbers. And, of course, marauding Indians, which is what Justice Kennedy alluded to or referenced in oral argument in Heller. So the first one is challenging a sensitive place involving, guns and motor vehicles. The second one is just a general ban on private property, guns on private property, unless the private property owner allows you to do this. This has already been struck down in New York by a federal judge, Judge Sinatra in the Western District of New York, although that decision is up to the Second Circuit Court of Appeals with a stay, so it hasn't gone into effect. But you already have one major decision saying that banning guns on all private property unless the owner has specifically given permission, is completely inconsistent with the tradition of firearms regulation in the United States, which when it comes to this stuff is almost non-existent, with the exception of very narrow sensitive places, of polling places, courthouses, and legislative chambers. Okay, so that's the second area. So the first one, again, is guns in cars, motor vehicles. The second sensitive place being challenged here is firearms on private property, unless the private property owner consents. And then the next two items, looking at this decision, involve bans on guns in libraries and museums, as well as bars and restaurants and entertainment facilities. No historical tradition for any of this. Keep in mind that the American Revolution, before the American Revolution, was discussed at places like Francis Tavern in New York City, all over, Boston, where people would hang out at Samuel Adams, bars and taverns and talk about politics. Obviously, they were all allowed to have arms, which we know from the famous speech given by John Adams during the Boston Massacre trial, where he admitted that people were allowed to have arms in Boston at the time of our founding, again, during the Boston Massacre trial. So a major concession by John Adams and compelling proof that the Supreme Court relied on in Bruin. So basically, there is no historical tradition of banning guns in libraries, museums, taverns, bars, any of these places, theaters. There were plenty of these things that existed during the time of the founding, and yet no historical evidence of any such bans whatsoever when it came to any of these types of facilities. So I don't see how the government's going to be able to establish that these are sensitive places based on longstanding American traditions going back to 1791. I should also mention one additional thing is as a reminder of the way this works, and I thought that the brief that I read by the lawyers for the plaintiffs here did a good job in a case, by the way, the name of this case is Coons versus Reynolds in the District of New Jersey. I thought they did a very nice job pointing out that the text, as defined by the Supreme Court, sets forth the Second Amendment rights we all have. And then once we can show, or once the plaintiffs show that the gun control regulation somehow falls within those definitions of the Supreme Court and the text of the Second Amendment, the burden shifts to the government to demonstrate a long-standing tradition of firearms regulation that's analogous to the modern-day regulation they're trying to uphold. And when it comes to what I just talked about, traveling with guns, private property and guns, entertainment facilities and guns, bars with guns, museums and libraries with guns, there's no 1791 historical analogs that would be compelling to demonstrate a long-standing regulation. Remember, it's not just about showing that there are examples of regulations. It also has to show those regulations were long-standing and continued far into the future, which I don't think there's any way the government can show, and they bear the burden once the text is implicated by the modern-day gun control, which it clearly is here. Okay, again, bottom line is we're going to have a hearing on January 5th in the District of New Jersey in front of Judge Renee Bum on a motion for a preliminary injunction trying to enjoin preliminarily, ultimately permanently, a lot of these sensitive places rules that New Jersey just passed. We'll see what happens. Certainly we'll be cheering for the Firearms Policy Coalition, the Second Amendment Foundation, and the other plaintiffs in that case as they work to vindicate our right to keep and bear arms. Okay, hope you learned a little bit something here today at the Four Boxes Diner. If you have not subscribed, please do so. We'll see you again soon. Four Boxes Diner.
Orders up. Table 2A.